Welcome to this litigation funding podcast where I speak to leading disputes practitioners. I'm glad today to be joined by Arty Rajendra, Head of IP Disputes in the UK at Osborne Clarke. Arty is also the current chair of the Intellectual Property Lawyers Association. Today we're going to be talking about the new cost cap for patent cases introduced into the shorter trial scheme. The IPLA played a leading role in developing the new cost cap. Welcome, Arty.
Hi, Emily. Thanks very much for inviting me to participate in this podcast. I'm very happy to talk about the shorter trial scheme. So it started off as a pilot scheme in 2015, and it was part of two reforms, the shorter trial scheme and the flexible trial scheme in the business and property courts, which were designed to streamline litigation. And I think, although they may not have been all of Colin Burse's idea, he was definitely sort of one of the leading lights and promoting it within the IP community. So the shorter trial scheme is basically, trying to get to a result, a judgment quicker, as you can imagine. It sort of says what it does on the tin. And like I said, there was a 3-year pilot scheme, but it's now permanent. And it basically means that you should get a trial within 12 months of issuing the claim, perhaps even quicker, but certainly from the first case management conference, which is the kind of a very early hearing that happens in any action where the court looks at the claim and decides what kind of evidence is needed, and with contributions from the parties, obviously, saying how they see it going ahead. You will have a trial within 8 months of that. And really importantly, I think, particularly in the current climate, you get judgment within 6 weeks of the trial. The only downside of it is that the trial has to be 4 days. And that includes pre-reading. So let's say it's half a day to a day pre-reading. That's only 3 days in court, which really kind of limits the number of witnesses you can have. You can certainly sort of make cuts to things like opening and closing submissions in some cases, not all cases, but some. But where you have several witnesses, the parties need the freedom to cross-examine them at the right pace, and 3.5 days may not be enough. So that's the shorter trial scheme, been around for a while. Uptake's been reasonable, but, we're hoping the cost cap will improve uptake even further.
Great, thanks, Arty. You're the current chairman of the IPLA, which played a leading role in developing the new cost cap for the STS. Can you explain the thinking behind the cost cap and why the IPLA pushed for this development to be introduced?
Sure. So just a little plug for the IPLA first. I feel I have to. So the IPLA, it's actually just a group of law firms. And what it does is act as a centralised voice for law firms that have substantial IP practices in the UK. And, our objectives are to lobby for change and improvements within IP practice in the UK. So in fact, the IPEC, a lot of the motivation around the creation of IPEC was because of IPLA. There was something called the Burden Plan, which was named after my predecessor, Michael Burden, who was previously chair of the IPLA. He said, look, we need a different route to litigate IP rights in the UK, and came up with a way to transform what used to be called the Patents County Court into now what is the IPEC. So that's one example of something that we did. We also do some work in conjunction with Oxford University to help train young lawyers in IP. So we work together with Oxford to put together the graduate IP diploma that Oxford run, and Bristol used to run. That's a sort of an IPLA thing as well. So we want to make the UK an attractive place to litigate, for it to continue to be an attractive place to litigate. And we want to streamline procedures and give party litigation options. So that was where motivation came from. I think there was also, an eye to what the UPC was providing and whether we could offer an alternative to that, or not, maybe not an alternative, but something in addition to UPC, and a really attractive, quick and cost-effective forum that's not IPEC, right? Because IPEC, as I'm sure we'll end up talking about, is for, the cost cap there is really quite low, but not unlimited, which is what you get with, most actions brought in the patents court.
I think that's really helpful, and I think we'll come on to the cost caps and IPEC as well in a minute. But if litigants are looking at the shorter trial scheme and they want to take advantage of the new sort of the regime and the cost cap, how do they go about doing that? Is there a specific procedure when they're starting their action that they need to go through?
So the cost cap automatically applies to all patent cases, and there is a very memorably titled PD 51ZD, which is now in force. One thing I would say, which I think is important, is that it's currently a pilot scheme. So it's in force for the next 3 years, and I would encourage parties and lawyers to use it, because if we don't use it, we might lose it. So it's still in the pilot phase, and it applies to all patent cases. Maybe we can talk a little bit about other IP cases and what the future might hold later. But it's a £500,000 costs cap for a liability trial, and then a £250,000 cost cap for the damages inquiry. And the aim is really about lowering costs of litigation, of patent litigation, and increasing certainty for parties so they know what their cost exposure is right at the beginning of the case, which is, why why IPEC has been so successful, because it provides both of those. But this does it for, slightly more complex cases.
Talking about the costs, I think IPEC, from a litigation funding point of view, is not something which makes economic sense because of the lower damages cap and the cost cap. Do you think that there's an additional potential risk if actual real world costs that the claimant is going to incur in litigating their case are significantly higher than the cap, that's going to actually disincentivize use of this scheme if they've got a good case and they think they're going to get a good cost recovery at the end of it?
That's a really good question. I think if we step back a bit, the reason why IPEC is different, I think, is that when the cost cap came in for IPEC, it was never really meant to cover the actual costs of the litigation. Now, there might be some firms and parties that can do a case under the cost cap, but certainly not in my experience, unfortunately. So in IPEC, I would say there's no real correlation between the actual spend of the parties and the cost cap. However, the STS cost cap is different. When IPLA, in conjunction with the IPEC Court Users Committee, came up with the cost cap, what we tried to do is analyse the data for the STS already, the cost judgment, the public cost judgments that had come out for patent cases. And the costs in those cases were about 500,000 or thereabouts. So we try to, not all cases, right? But, as a kind of broad axe, it seemed to be around the right number. And it's, like I said, a 3.5 day trial. It might, there will be cases that will be more expensive than that, particularly if there have been various interim applications and things like that. But 500 grand, you should be able to do a 3-day trial for there or thereabouts. So hopefully it won't dissuade litigants from using it. But if it's not right, then they can always just go directly to the Patents Court, where there's an unlimited cost recovery. So there is an alternative option. But we think there's a kind of unmet need for those types of cases where they're not IPEC, they're not full whack Patents Court, they're kind of in between. So hopefully this will fulfill that need.
I think I've seen that after IPEC was introduced, there were more cases being litigated than previously. So I think that sort of pent up demand argument seemed to kind of bear out there. What about other kinds of IP though? So this has initially focused on patents, and I think the data so far has been that there's been more patent cases under STS than other types of claim. But why exclude copyright, trademark cases at this stage from the pilot?
Well, you've picked on something that's kind of close to my heart, because I have quite a mixed practice. I do a lot of patents, but I try and keep my hands in on copyright and trademarks too. So I would absolutely love for this cost cap to apply to those cases as well. And I really do think there is, even more of an unmet need for those types of cases where parties perhaps don't want to expose themselves to the potentially enormous costs that you might get in an ordinary high court action. It's really pragmatic reasons. One, we didn't have the data that we had in patent cases to enable us to land upon an appropriate number, which we did for patent cases. and you kind of want to do these things on an evidence-based approach. So, if we can, maybe a plea to your listeners, if they have some evidence of cost judgments in other IP rights that have been litigated in STS and they are around the 500,000 mark, we can use that. And also, it's because the Patents Court has a sort of different setup, and changes can be made perhaps quicker, because you've got a judge in charge of the Patents Court, and it's not ordinary sort of business and property business. Then it was something that could be done reasonably quickly. Although I would say it's not quite as quick as we would have liked, but it's I'm not complaining. It's here now.
Yeah, I think there was some discussion to try to sort of get it to launch ahead of UPC, but it's
I think that,
it's
well, yeah, I remember one of the first big meetings we had, which was in conjunction. So when I say we, IPLA had with IP Bar and IP Federation, was the first big meeting where we were kind of launching it and getting everybody's input, and before we could take it to the judges. And that was pre-pandemic, so so it's taken a while, but we've got here, and it's been probed and tested as is right, and interrogated, and we're now here, so it's great.
Yeah, I think a lot of things were derailed by the pandemic, so it's good that that was only temporary here. One last question, in terms of how parties kind of mitigate the adverse party cost risk. So I'm quite familiar with parties taking after the event insurance, or ATE, to mitigate that adverse party cost risk. And that's obviously available for all kinds of cases in the different higher court tracks. Do you think that other sort of mitigations will have an impact on the uptake, on the use of the shorter trial scheme with the cost cap? Or do you think it's just an additional tool?
So you're definitely the expert on ATE, and have a well stolen a march on me, because I don't really know huge amounts about it, but they're not mutually exclusive. I think you could do both potentially, and all about sort of access to justice and enabling people to fight cases that they want to fight. I guess maybe a difference is that the STS cost cap may open up litigation cases for bigger companies that perhaps wouldn't ordinarily use ATE, but nevertheless have cases that they want to run. But for budgetary restrictions, they can't run everything. So I think there's a gap there. And then I guess there's some issues over premiums and on ATE. I'm sure they can be managed, but obviously that's an additional cost that wouldn't apply for those that don't have that kind of insurance. So yeah, I mean they're not mutually exclusive. They may be able to work together, all to the benefit of litigating parties.
Yeah, I think in ATE, I mean, the premiums are still quite high because the market is more open than it was, but it's still quite a limited market. So I think, I mean, if you win and you've got ATE, then you're likely to have to pay a deferred premium from the damages, which will be sort of an additional kind of cost of the litigation, even in the event of success. So the two may not work together that well, because you may still have a portion to pay, which would then come from the damages. I think also, I mean, ATE, how willing insurers would be to insure non-damages bearing litigation, so injunction or any other kind of declaratory relief, is a question mark, because if they want to recover something from the back end, then there's going to need to be a back end rather than having an upfront premium. If it's all upfront, I've seen the costs are really chunky. So
okay.
It's a budget and additional budgetary item right at the start for the claimant if that has to happen. So,
well, hopefully this gives the cost cap will give another option, rather than people having to look at ATE, and they can use the cost cap to give them certainty instead, and manage costs.
Yeah, absolutely. Great. They were all the questions I had. We've been really quick. Was there anything else you think we should cover?
No, not at all. I mean, very boringly, I'm going to repeat my plea about parties using it, because I mean, I've certainly had cases where clients have equivocated over whether or not to issue the proceedings, and they've had good cases, but the costs, the exposure is so massive if you lose, that it probably doesn't make sense. So I think if we can encourage parties to use it and get some good data around recovery rates as well, give people more confidence in the in the pilot and make it permanent, hopefully.
Fingers crossed. I think if confidence in English court litigation is a good thing, so let's hope that moves forward. One other question I'm going to ask is, I think the adverse party cost regime or cost shifting is quite helpful in deterring less than meritorious cases. So I think we see a lot of, I'm going to say, kind of more trial and claims in the US just be issued on maybe weak patents. Do you think that having a cap is going to encourage more of that litigation to come to the English courts?
So that was definitely a factor in the discussions around this when we were originally talking about it. And there was quite a strong resistance to it for that precise reason. But I think, weighing everything in the balance, the view was actually this is still better than not having a cost cap at all and leaving it, because it's still quite a fair chunk of money. I mean, if you think about, obviously the litigating party has to bear, the losing party has to bear its own costs as well as exposed to another. So it's still, million and plus exposure, which is not to be sniffed at. So I think you're right to raise it, and it was a concern, but overall, we still think this is the right course.
Great. Well, I'm excited to see what happens, and thanks very much, Arty. It's been really good to speak, and let's wait and see over the next 3 years, and hopefully this will be broadened to other kinds of IP and enable others to have some access to justice without that downside risk.
Brilliant.